Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And salam sejahtera. So today I'm going to give a recorded lecture regarding the law of contract. This is a part 2. This is a part 2. There will be 3 parts. The part 1 that we have discussed before through the synchronous class, right, regarding the elements of the law of contract, right? So if I can recap the elements that we have discussed in the first part is the offer, right? First the offer, the second is the acceptance, the third one is intention to create legal relation, and the fourth one is consideration. So today we are going to discuss the second part of the law of contract, that is the capacity to contract and also the certainty in the contract. So these are the another two elements that form a valid contract, right? So basically these are the learning outcome, right? First, to discuss the elements of capacity to contract, as well as to explain the certainty in the contract. So make sure that you focus on these two kind of learning outcomes, right? Okay, so we start with the capacity to contract, right? So when talking about capacity to contract, there are several provisions in the Contract Act. So I put this Contract Act CA as a Contract Act, Contract and 1950, right? Okay, so according to Section 10 of the Contract Act, it states that all agreements are contract if they are made by the free consent of parties competent to contract, right? So I highlight important point here. Say, okay, all agreement are contract if they are made by the free consent. So the second is free consent of the parties and competent to contract. Lawful consideration with a lawful object and not hereby expressly declared to be void. So the opposite of the void is a valid. So all in all, based on these provisions, as long as the contract is made or is entered into by the free consent, competent parties, number 2, number 3, lawful consideration with a lawful object, or 4, they are declared as a valid contract, right? Okay, it goes further in section 11, right, where section 11 provides that every person is competent to contract who is of the age of majority according to the law which is in subject and who is of sound mind, and is not disqualified from contracting any law to which he is subject. So basically under section 11, so the main point here is age of majority, number 1, right? Second, sound mind, okay, and the last, he is not qualified from contracting by any law. So all in all, there are 3 major points in the section 11, that the person is competent to contract, is age of majority, he is age of majority, he is sound mind, and he's not qualified from contracting any by any law. Okay. Okay, so these are the three that I've mentioned just now. Three major points here. We go one by one. Okay, first is the age of majority. So the age of majority is not defined under any provision in the Contract Act, but it is defined under the Age of Majority Act 1971, whereby Section 2 of this Act define that person attain the age of majority at 18, okay, as long as that person is 18, it is considered as a age of majority. So age majority meaning to say he is an adult. So below 18 years old, in other words, he or she is not capable of entering into a contract, a valid contract. So this is as decided in the case of we have one case here, Tan Hee Juan versus Teh Boon Kit. So it happened in 1934, where the Privy Council held that the effect of Section 10 and 11 of the Contract Act of the India is that an infant cannot make a contract within the meaning of the Act, and that the contract made an infant is not only voidable but void. So in this case, the Privy Council, is actually is a bench of judges, of English judges, uh, uh, decided the case, right? So in Malaysia, we have experience where we uh, requested a decision by the Privy Council, not mistaken, prior to 1985. So the Privy Council had actually made a certain decision in Malaysia. So in this case, it's actually is mentioned about India. So I believe that you are wondering why India, because our in Contract Act, our Contract Act 1953, 1954, sorry, 1950 was actually more or less identical with the Indian Contract Act. As you know that India is one of the Commonwealth countries, so their laws are more or less identical with ours. Okay, in terms of system and the we call it the system of law and the judicial system, they are more or less identical with us. Okay, even though that the minor, we so call the minor, so people under the age 18 we call as minors. So even though they are barred from entering into a valid contract, the law does mention uh, give actually 5 exceptions to this general rule. So one of the exception is that when the contract is entered into for a necessaries things, necessaries. Okay, in this regard, under section 69 of this contract, it says that if a person incapable of entering into a contract or anyone whom is legally bound to support is supplied by another person with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. Okay, so this in summary, this section 69 explained that since the contract entered into by minors is void, the person who has made that supplied the necessaries can actually get back or reimburse from the property they has given to the minors, right? So in other words, even though it's a void contract, so that the that person the person who have given that supplied the necessary can get back the property or things that they have supplied to the minors. Right. The second exception is about scholarship agreement. So again, it's not mentioned under any provision in the Contract Act, but instead it's mentioned under Section 4, Subsection A of the Contract Act Amendment Act 1976. Amendment means the contract has been amended. The debt provision in Section 4A has been amended. Prior to this amendment, it might be there is no we call that scholarship given to the minors. So it says that notwithstanding anything to the contrary contained in the Principal Act 1950, Principal Act means the Contract Act. No scholarship agreement shall be invalidated on the ground that the scholar entering into such agreement is not at the age of the majority. So, in other words, prior to this amendment, the minors cannot enter into a contract of a scholarship. Only after this amendment, the law actually give some relief to the minors that they can actually enter into a valid contract for study of a scholarship agreement.